suggest we segue to Dan Sulmacy, who will introduce the topic of compensation on behalf of the Commission and the thinking today about it. And Daniel and Karen, if you would like to stay at the table, we would be happy to include you in the discussion. I see nods, right? Good. And let me just remind everybody who's attending that if you have any question or comment you would like to make, there are cards available. If you look back there, one of our staff members, Michelle, has cards. Just get a card, write down your name, and fill out the card with your question. They'll be passed up, and we'll be able to, time permitting, we'll go back and forth between commissioners and any questions or comments there. Let me also say that we have a designated federal officer and our executive director, Val Bonham. Please stand up. And I'm going to take this opportunity to ask all the staff members of the Commission to stand up. So before we continue, just as a good segue, let us all thank them. They've done tremendous work. And with that, Dan, if you would present, and we will, after Dan's presentation, we'll continue with questions and deliberations on this.
Well, first, let me say this is radically incomplete. We had about a week and a half as opposed to 2 years to come up with about 5 pages instead of 150, but we've benefited greatly from the work of past commissions, from your work, Dan, and others. There are lots of thorny details and practical barriers that I think we've heard a little bit about, but we thought that the first thing that we had to say was there's an ethical obligation that might make the effort worth it, and that's what I'll concentrate on. So the first issue that we confronted was a possible complaint that our job is to protect people. How is this protection if they're actually already injured? And we tried to make the distinction between a sort of primary and secondary sense of protection, which I think dovetails nicely with what Dan said. The analogy we use is to a lifeguard whose primary task is to eliminate risks that people might have of drowning, but also has an obligation, if people do drown, to save them under those circumstances, and that's broadly considered to be protection. And so we think that this falls under protection of human subjects. Still, why would it be justified in human subjects research? Several facts. First, that as was already mentioned, the benefits of the research redound to the common good, while the risks are borne primarily by individual subjects. I think we all know that. And the risks are not readily foreseeable. And it's another way of saying some of what Dan said, but the way I've put it is that the uncertainty is an essential aspect of the justification for the research to begin with. And we have to recognize that's an absolute fact. Now, the counter-argument, as you heard, is that volunteers may be motivated. One of them is that volunteers may be motivated for reasons other than the common good, and they're not motivated for that. And the reply would be that regardless of the motive, they do contribute to the common good, and their contribution is morally significant. Many have said that there's a need to compensate those harmed by responsibly conducted research, 30 years of presidential commissions, most other developed nations. Our own international task force on this issue raised the question of why we're not doing it. And the basis that's primarily used, as Dan said, is justice and fairness. And the primary argument against this is that subjects freely consent to these risks, and therefore they waive their claims to compensation, this sort of free assumption of risk argument. The counter-argument that we want to pose is that a just society can protect persons against bad deal contracts, and it's not paternalistic, but a determination that such an arrangement is just inherently unjust. Just as we protect subjects from unnecessary risk by preventing trials that are too dangerous, we can protect them, as Dan just said, I'm almost on harmony here, we can protect them from signing away this form of secondary protection. And the paradigm example for this kind of case, I think, would be the NIH-sponsored phase 1 trial for a sick patient without further therapeutic options. If you take that as the first paradigm to think about this, it's high risk, There's little individual benefit, less than 5% historically. Extreme uncertainty, again, that's the reason we're doing it. There's public benefit even if the trial is negative, because then we learn from that. The subject is incredibly vulnerable. They may be biased in terms of their own optimism into this, either unrealistically, or it may be a coping mechanism for them that would lead them into this trial. It may be that they're purely altruistic, although that's apparently fairly rare. Few are even aware that they've waived their right to compensation because of reasons we heard about before, that even one of our presenters yesterday working in academic research said he didn't even know that people waive their risks because it's buried so deeply in the consent forms that they waive their rights to compensation. I think in some ways their freedom is even compromised, or they're making this heroic act of self-sacrifice, and in either case, I think it's fair to compensate them if they are injured. It may be suggested then that since the motives of the investigators are mixed, and they may be experimenting for profit and not the claims of and therefore their claims of the common good are false, that this argument doesn't work. But our counter-argument there is that even in that case, the subjects are recruited under the presumption that they're serving the common good. So even in the for-profit pharmacy research, the person said, why are you signing up for this? Well, it's help other patients who might be using this drug in the future. So even if the motives of the investigator are mixed, that's the claim that's being made to recruit the person as a volunteer. And in fact, to the extent that the subject is recruited under the claim of serving the common good, but this is not truly the motive of the investigator, then a claim of justice might be even more significant because they might have been recruiting them under a sort of false pretense. The paradigm here might be the subject recruited to participate in a phase 3 trial of a Me Too drug by a pharmaceutical manufacturer. But I still think the claim for compensation works there. Still another objection we considered could be that some research seems closer to the free market conditions of a laborer and an employer, such that as phase 1 trials of a new cosmetic drug for baldness, where the person was recruited and they're really unemployed and uninsured, right? So this is the subject as wage earner. Well, here, if you adopt the wage earner model, then you've got to ask how such subjects would be justly excluded from a workman's comp system, which, if that's the model you're using, that's what ought to be here, that society is deemed just and required of all other wage earners. Moreover, besides these considerations of justice, to the extent that the research is biomedical, then clinical medical ethics, I think, commits us to beneficence and non-maleficence towards the individuals in these trials, and that would dictate that clinicians not engage in the research unless they can assure that there's protection for the subjects they're enrolling in the trials. And finally, I think general utility might best be served by such a system. First, by reassuring potential subjects and therefore potentially increasing subjects' recruitment into trials, and lastly, secondly, by reducing potentially, and we heard maybe some suggestion of that, the cost that would be associated with resorting always to torts is the way to do this. Torts require proof of negligence, and again, shared uncertainty about risk is the ethical basis justifying the research in the first place. So you can't sort of make the claim of negligence there. Strict liability, as we heard yesterday, I think is counterintuitive, requires the courts anyway, may not be the best way to go. We certainly stand, as Amy has said, open to the possibility of torts for other damages or claims of negligence. Scope of coverage then became something, so I think our committee is sort of in agreement with that, although I've reframed my outline in a way that I'm not sure that Anita will recognize in terms of the way she wrote it up, but this is what I was intending when I wrote the outline. Scope of coverage, we certainly want to include medical care, and we would think including psychiatric care. We are open to the possibility of other things, but we heard some strong advice yesterday about maybe not wanting to go beyond medical care. Next, we distinguished and want to distinguish sharply between compensation for the costs of medical care for those harmed by responsible research and reparations towards those persons or communities who've been victims of unethical research. And we think that there's a distinction between those two that we wanted to draw. And then we reach the part where we have very little consensus, at least among the three of us writing, is the design of such a system. Because of the practical considerations, questions about whether we should be making the sponsors responsible for this, questions about adding to the burdens, to the researchers, and the many models that are involved led us to not be able to actually, as a committee of three, actually come to a conclusion that we would endorse a system of compensation outside of what's already there. I mean, the argument essentially is, there haven't been a lot of people coming forth saying they're complaining about this. Somehow all the care is getting covered. If it's not broken, don't fix it, is the sort of argument that we heard, and we were unable to come to a consensus that we do have a broken system, and that's for the rest of our discussion. But I think we did come to a consensus that the persons who are harmed do deserve to have their care covered. The question of how to do that was something we were not able to come to consensus on.
Let me just ask, let me just take from what you suggested in your deliberations, a possible recommendation, because there is the overwhelming sense that compensation in principle is the right thing. So the possible recommendation was that the federal government study the issue of research-related injuries to determine if there is a need for a compensation system. That could be even stronger.
Yeah, that's pretty weak.
If possible, there is a need for one if you can create one. So having a pilot, figuring out how to create one is the challenge, right?
Yeah, well, we were not, and maybe Nita can speak, we were not even at the stage of saying that there is a need for anything to be done, and that was part of the dispute. That just going along as we are might be possible, and maybe Nita can speak to that.
It may be worth hearing what the other issues are from the subcommittee.
Of course.
And why? So what you just read as a potential recommendation is something that I think we may have broader support on, but the stronger case of it we may not. So I think Dan is absolutely right that we seem to reach a shared consensus that there may be an ethical case for compensating research subjects. But the concern that I had and that we discussed was the imprudence of recommending an alternative to the sort system without understanding a few things first. The first is that past commissions have approached this issue quite prudently. They've recommended determining whether or not a system is actually needed, and if so, how to design it. Second, there's no evidence that the tort system and the status quo more generally, right? So systems like the University of Washington system, systems in hospitals more generally, what we heard about yesterday from industry, that the present system fails to compensate individuals, and not just through suits, but by its mere existence, which may cause settlements, and whether or not, in fact, there are people who are not being served by the current system. So we think that's an important thing to understand. Third, so past carve-outs to the tort system have either been ex post under extraordinary circumstances, or the ex ante ones, like vaccine or workers' compensation, arose from special circumstances, like the vaccine manufacturers who refused to stop making vaccines unless there was some alternative system. And those systems did serve as preemptive systems to the tort system rather than additive systems. In addition, all of the past recommendations arose before the Affordable Care Act was enacted, in an era when all U.S. citizens, and thereby in an era where all U.S. citizens and all research subjects will be insured. This is going to raise incredibly complicated issues about the cross-cutting between different insurance models. So as we just heard, Medicare won't cover injuries that arose from research if there is another form of compensation that's paid. And in an era when everybody will have health insurance, what this means, whether or not they're not going to be able to receive insurance as a result, needs to be studied. And then there are reasons why it might be particularly costly and difficult to make it an administrative system. So unlike the vaccine cases, there's not a limited number of signature adverse events. How do you define a compensable event? Is it any adverse events? Is it particularly severe adverse events? Research occurs in uncontrolled research environments where many people are asked to take medications at home outside of a clinical setting, unlike the vaccine case where they're actually administered in a clinical setting, so issues of causation become even more complicated. And if the individuals that we're really worried about are just the uninsured rather than their insured, then what this might encourage is, in fact, the most vulnerable individuals who lack health insurance enrolling in research programs simply to have access to medical care. So if, given all of these different issues, putting aside the fact that there may in fact be an ethical case for compensation, it seems like there's a strong case for asking the government to study and see if a compensation system is needed in light of these issues, and if so, what that model should look like.
So can I just modify one word or two words? There is an ethical case for compensation. Then the question is whether there is a need for something new to be done. There is no compelling, set of arguments that would deny that there's an ethical case for compensation, and then we could go on from there.
Well, so the only reason I
have to agree with you. I mean, are we ready as a commission, or when would be ready as a commission to deal only with the second issue? Because are we ready as a commission?
Well, I did say
we are convinced, based on the arguments of this group.
I did say if intentional.
Ethical case.
I did say if intentionally, and the reason I said if intentionally is because I do agree that there needs to be reasons explained for why this is a special carve-out as opposed to other areas in which people engage in socially beneficial activities. And so is there a justification for carving out this group of people, even if we think that healthcare should be covered for people who are injured? Is there something special and unique about this group?
Yeah, and we've been hearing...
I think that the whole argument of individual risk for public benefit says that's a very unusual circumstance. I guess I would be comfortable concluding the first part of that, and then
I think there's a huge amount of discussion about whether a better system could be designed, and I think that's the bulk, everything but those two words of maybe. There may be an ethical case could lead us to a broader discussion of what we want to recommend with regard to the second part, which I think there's a lot of discussion needed. But I think Jim is right. We should ask, is the commission convinced that there is an ethical case for compensation in this?
Yes.
Not
Yeah.
necessarily.
Okay, go ahead.
I think, the arguments have already been made. Dan already talked about, the cases as to why, if the patients were willing to enter into the trials and, that they're assuming the risk, then, then there may not be a special need to make a case that, you have to compensate them. And when you say compensation, it's also very important to define what the nature of the compensation is. Right? When we use general term of compensation is much larger than
We've narrowed that.
right. But even within the medical expenses, I think there are lots of sets of issues. And with some of these trials, for example, the risk is very high that patients may get severely injured or die. But how do we deal with that?
Roger, are the subjects actually agreeing to assume the risk or agreeing to take a risk? And I think there's a difference. The former, it seems to me, implies that they are willing to assume also the consequences of taking the risk. And what we're really, and when I think of, what I think of instead is the subject saying that they agree to take the risk. And particularly, it would be helpful, and it seems to me the subjects are more inclined to do that if in fact there are mechanisms in place to help them assume the consequences of that risk. But I'm not sure, I'm curious what the interpretation here is when a subject signs on to say, I'm taking the risk, or I am willing to assume all responsibility for it.
I still don't think that what he said, though, disqualifies what you asked about, is it an ethical
Right.
responsibility?
Right, yeah.
Just because of what you said doesn't convince me that that's not ethical, that it's not ethical to treat them. So was there something more?
Both the dams, both
No.
dams made the argument that, and the argument has been made over and over again, and there's I see no effective counter-argument in the literature, that given the standing ethics of conducting research on human subjects, whether you look at Nuremberg or anywhere beyond, informed consent is not the only criterion. It's also because there's an ethical requirement not to subject human subjects to unnecessary risk or non-protection of the harms coming in,
So I give
out of injury. So that's the argument that's been made over and over again. Whether some of the things you raise, indeed all of the specifics you raise, are questions of what kind of system you can devise that's practical and affordable.
So the clinical studies, they're quite wide-ranging, and at one end of the extreme, for example, in certain types of cancer trials, for example, that the kind of risk that the patient is assuming is actually death. And I don't think that there is anything greater risk than death. And yet, they actually, willingly come and join those trials with, and of course, the idea that we need to do everything to protect them is still stands.
Right.
But so the question is about assuming risk. The fact is they could actually die, from whether it is treatment associated or not, or sometimes it may be treatment associated.
Lonnie, and then I'm going to let Anita.
I
say
understand
in the
what you're
subgroup.
saying,
Yeah.
but usually people who, and correct me if I'm wrong, who enter into those types of trials
The alternative is.
have no alternative.
Yeah.
It's a last-ditch
Death.
effort to save their life, extend their life. But what you could say, and just because they're in that trial, and they're in there for a reason that mainly benefits them too, hopefully, if it doesn't benefit them, and they know they're taking the risk, and they know that it's going to advance your understanding of the drug and what it will do for other people who may get cancer, for the public good, that's not to say that there's not some responsibility. If it doesn't work, what are you going to do? I mean, you talk about what is the responsibility, what kind of care are you going to give them? You're just talking about medical care. It may be just giving them palatable care, making them comfortable, or something of that nature. But I understand what you're saying, because I've thought about that too. It's, what if people enter a clinical trial and really the risk is death? I mean, but they know that without it, they're going to die anyway. So it's really, it's one or the other. But with what you're doing in the clinical trial, there might be an opportunity to live longer, to have a better quality of life, or to make some kind of advancement. So I understand what you're saying, but there's still, I think, an ethical responsibility, even if you know that clinical trial or that drug did not work for that individual, and it's not working, you're still going to make them as comfortable as you can until the end, correct? I mean, as far as, I assume that kind of cost of care? Raj?
Raj, do you
No,
want
Does that
to-
make sense?
I'm listening to the argument.
Okay,
so-
okay. Anita. Very good. And we're going, I will, at some point soon, move on to the question of systems, because there's a lot to be done there, and our time is limited, and we obviously can come back. But
Yeah,
Anita's
yeah.
also on the subgroup that that spent a lot of time on this. So Nita, why don't you?
Thank you, and I enjoyed very much and learned a lot from working with Nita and Dan on this issue. I have reached a conclusion that Dan has reached, that compensation of research subjects is just, it's fair, it's humane, it's ethical. But I also agree with Nita that there are a long list of practical concerns about implementing a system of compensation. And I think that what we heard yesterday from Mr. Feinberg, what we heard today from Karen, that these considerations are maybe even in some ways more complicated than I thought 3 days ago. Notice how the use of the tort system that's the default in our country, and it's not perfect, it's slow, it's cumbersome. But it also has a disadvantage that it's really not going to help anybody unless the tort system changes. It's a 50-state system, and we have to wait for the slow process of judges to come around to the position that this very new thing ought to be covered. And so if we say, well, there's always the tort system, we're really not being honest unless we're talking about negligent injuries or intentional injuries. Because there's right now not a single tort doctrine in any state that covers a investigational drug or device on a strict liability basis. So what are we saying when we say, well, we could have a sequential process of tort plus compensation? We're saying maybe we'll settle with the people that try to use the tort system. So even I think that the justice of the compensation, I agree, I think most of us agree, with a couple exceptions. And on the just the specific question of the voluntary consent, it's a very, in a way, American ideal that someone should be able to autonomously, as a moral agent, agree to take on a non-compensable risk for the sake of health care or the public good. That's a very noble idea. But we don't expect that of almost anybody, right? The soldiers and the sailors and the Marines who go into battle, they assume a grave risk of death, but we take care of them through the VA system, right, if they get injured. And the workers in heavy industry who get hurt on machines that we don't understand, they get workers' compensation, even though they assume the risk of those jobs. So I understand the attractiveness of the notion that there should be voluntary informed consent, but I just don't think that's the way the world works in very many instances at all in our country. And I don't think that research subjects should be sort of treated as this category of people who, unlike soldiers and sailors and Marines and workers, get nothing if something bad happens to them.
But it has worked.
Amy, can I just clarify on what I said before? So I guess I'm somewhere between where Raju and Anita just spoke, because I do think that there is a strong ethical case for reimbursing or for paying for injuries for research-related injuries. But when I say that, that doesn't mean that I am comfortable saying that every injury should be covered or what that system is. And so, to me, it could be the case that the tort system already serves that purpose, and that the existing model already serves that purpose. But I do think they should be compensated. The question is, do we not do that adequately today?
Excellent. Well, thank you for clarifying, because I was really taking this, and as chair, I tried to just get us, I don't have a prior on this about the system. I do have a prior because this is something I've read all the literature, I've heard these wonderful presentations, read what our subgroup is. There is an ethical case for compensation. That does not determine, Raju, whether or not our present system is as good as it can get, speaking both ethically and practically. There is another set of issues that we've heard some testimony about, and there is some, but far less literature on, interestingly, than the first question. So now at least I think I'm very pleased and with your clarification, because I think we're we can at least set the first aside as a consensus. Raju will talk and see if we have a unanimity here, but it opens the question of the question about what kind of system would work best. Christine.
Thank you. I absolutely agree with the ethical basis. I have no question about that. So what I want to ask and offer a few suggestions for if the system isn't broken, why fix it? And one is a question, I think, for Karen, and maybe a comment to Nita's list of possible reasons that the current system might work. And that is, as we've been studying this issue over the last months, it's clear that increasingly research is getting very complicated, multiple sites, cross borders, et cetera. So I'm wondering what happens to international participants of University of Washington sponsored studies. The care that they might need from an injury can't be absorbed by the system unless you bring them to Seattle. So what happens in those cases is part of the question. And do we need to think about how our current status quo system deals with people in this increasingly complicated multinational research environment that we are in? The second question I have is about the one related to whether or not creating a system would push us to preferentially want to enroll people who are uninsured. And I think it's at least possible that the opposite is true. That, you know, to the extent that people who are in research need care, and need care independent of injury, but also when there's an injury, maybe there's an incentive already to exclude people who don't have insurance, because there's, especially in systems that don't have a system like University of Washington, that they may say, you know, if we enroll people who don't have insurance and they get injured, we're stuck. Whereas if we only enroll people who have insurance, then, you know, then we can have the insurance take care of their care. And so I don't know if we know the answer to that question, but I think it's at least possible that that is already happening. So I don't know if you have anything to say about the international group, and then that's...
Yeah. Sure. So anybody who is injured outside of the general Seattle area can always use the $10,000 out-of-pocket reimbursement to fly to Seattle and obtain health care in the Seattle system if they want. Of course, that's not practical for most people. So what generally happens in other countries is it's on a case-by-case basis. If there is a national health insurance program that we consider to be the primary payer, and we expect our researchers or their local staff to assist the subject in navigating that system. We would then provide any out-of-pocket expenses over and above that out of the $10,000 reimbursable component of our plan. And also many of our international research studies, not necessarily the ones that are funded by NIH, but the ones funded by the Gates Foundation, for example, have some sort of provision in those contracts in other countries to provide health care to anybody who's injured, usually by the researchers and their staff on the ground.
Thank you.
Can I address your second?
Sure.
So I think that may be the case today, right? It could be the case that people look for people who are insured such that they are not stuck with their care unless insurance starts to have the policy of, if you have a system of compensation, then we won't actually pay you for research related. What I was imagining is, under the Affordable Care Act, everybody is supposed to purchase insurance. If not, you get penalized for not doing so. Some people may choose to nevertheless not have insurance. Those people, I'm imagining, would be the most vulnerable and most likely to then enroll, because everybody else would in fact be insured. Now, it might be that you're right, which is at the other end, the investigators would exclude them, and so therefore it wouldn't be as much of an issue.
Yes, Roger.
So I want to pick up on this issue, that Christine just talked about, as to whether the system is broken and whether we need to fix it. So one of the questions that I wanted to ask is that, we won't say how long ago the other presidential commission made the recommendation, but made the recommendations, and I think, it's a long period of time, and that those have not been implemented. And so we have now experienced, the society as a whole, moving along with the current existing system. And I think it is important to be able to document that not implementing this, this system has harmed the society in some way, and not only in a qualitative way, but in a quantitative way, and say that, if we had the system that we would have done something. And I haven't, I haven't heard any information about what is the damage that has been done, right? I mean, if a law is passed, if you want to take it to the Supreme Court, you need to show that some damage has been done to somebody. Somebody was injured as a result of the law, otherwise they won't look at it.
That's
I mean,
why
so is
we're
it?
not illegal.
I understand. I'm just making an analogy here that, this is a responsible body, asked by the president, and sort of we're deliberating on this issue. So it's not enough to say that, this is, this is broken, but I think it's important to show how it's broken, and that would, to make a case, it would be good to find that.
Since we kept Dan and Karen here, I'm going to pose this to Dan. The challenge is, why do you think the system is broken?
I don't have a survey to hand you.
I know that.
The thing is that, the absence of documentation of problems that may have faced individuals who weren't compensated doesn't mean that there aren't such people. They just haven't surfaced. So, it's not your place to hand the president a fully worked out plan. But if you said that it would be irresponsible to continue without a compensation plan unless you do the research and shows that actually there have not been such cases, a lot of such cases. For all we know, there have been a lot. We just don't know. Now,
To play devil's advocate on that, Christina's telling us it was $250,000 over 5 years plus $8,000 a year on a research budget of $1.5 billion. Doesn't seem to be a very big problem.
yes, that's right. So, I mean, what it means is also it's a very low-cost fix. So if you don't know how much of a problem there is, all we have is the experience of one progressive institution, which turns out, if I heard you right, this $10,000 per person cap, you've paid out a total of $8,000 in a given year for all the subjects in this $1 billion-plus research. Incredible, right? Now, can I just throw in one extra thing here? You were asked a very important question of whether or not your plan could be imitated or instituted in much smaller systems, and the answer is, well, I don't know. Do we really want a country in which whether a human subject has this aspect of their care covered depends on how big the institution is that the researcher works for? What kind of justice could possibly be consistent with that? And finally, one would hope that with just a sort of a national default system, all of the expenses that go into separating out your expenses versus other expenses and deciding whether or not this patient is covered and that one's not, given that all the institutions sort of blur their research together, that would go away.
I wasn't asking an ethical question. I was asking a question about implementation.
Right.
So, and that's why it's very relevant, because an institution that has $1.5 billion of research funding per year and has a world-class, huge medical care system has a different flexibility than, for example, the University of California at Riverside would to do the same thing. And that's really important for implementation.
It is, which shows that to say, look, we have one great success, everybody else out there, if you think there's a problem, you do the same thing.
Right.
That's not good advice. What it basically means is that the places that don't have that scale and all that expertise, they're not going to do it, which means that it's going to be a patchwork of just and unjust contracts.
Go ahead, Dan.
Yeah, I was going to say that I think what you what we probably have, and we don't have the data on this, is sort of already a patchwork of investigators who, for various reasons, try to do the right thing when these things happen, but without any specific funding for it, without any mandate to do it, with evidence already that insurance companies have begun to change the way in which they do it, and there's no reason they can't make the next step of saying we're not going to pay for it at all, and there's no guarantee that they will. Sometimes study sections will require that there be, redress within the grant. So even on the kinds of survey research that I do, it says that, if someone is upset by the questions you've asked them about dying, that you must have them see a psychologist. But there's no payment for that by the government. Who's paying for this? It's out of the largesse of one institution that's really taken corporately its responsibilities seriously. And the others, people try to patch it together, and that's sort of how we've, I think, limped along. And there may be, more serious problems we haven't heard about, but I think that's what's happening now. But we don't have absolute data about it, but that's the kind of thing that under the radar is, I'm sure, happening.
Sure, we don't have any hard and fast. Yes, thank you. We don't have any hard and fast data about why or how the system doesn't work, but we do have a couple of observations I'd like to share with you. One is that most individuals are not served by the tort system well, in our experience, because most of the adverse events that we treat and cover with our compensation plan are small ones. I think we're focusing here in our discussion on these really large events and on death, but in fact, most of ours are things like, I have a list of some of the most recent ones. Somebody was chewing on a vitamin wafer, fractured an old filling and crown on a tooth, saw her own dentist, and we covered her dental bill for $245. That's not going to go through the tort system. The second point I'd like to make is to challenge the assumption that if somebody has private insurance, that insurance or Medicare will pick up the cost of reimbursing the injury or covering it. That's not correct in our experience. Medicare will cover the cost of, quote, routine complications for clinical trials that are covered. That doesn't cover a lot of unanticipated problems. Private insurers are even more reluctant to cover the costs of adverse events that occur in clinical trials.
If I may.
Yes, please.
So I think we're arguing we're sort of mixing the two questions. The first one of which I think most people have discussed, which is ethically or should we be bound to compensate, I would hate to say the word victim, but patients that are involved in research, regardless, and so leave the payment part out of it. So I think everybody fundamentally agrees on that, whether it's through a tort system or through a compensation system. And so, as General Bradley said, novices talk strategy, professionals talk logistics. And so, really, I think what we're arguing about now is what is the best method in order to compensate people. And so, but I think we have to get over that first hurdle first. I think everybody agrees if somebody is harmed while participating in research that we should take care of them. Is there any argument about that?
The only question is, for every single kind of harm, for every adverse event, or is this just a general statement?
That's
right?
the logistics.
Well, I mean, so I think we can all agree at a high level, which is, research subjects should be compensated, and then that doesn't necessarily mean every single thing from a, dental filling to a nausea, everything else should be compensated.
Yeah.
So the tentative, and I emphasize tentative, this is all subject to further revision, recommendation was beyond the strategy, now what you call the logistics, or I call the practical, to recommend that the federal government study the issue to determine whether we need a revised compensation system. In other words, let me frame it, because I see where we're coming
I think it's pretty important.
close. We're actually at 10:30, but we're going to be flexible and give ourselves another 10 minutes on this, and then we'll go on. Let me frame where we are. Many, if not all the commissions that have studied this subject before have recommended that have agreed that there's an ethical case for compensation. The International Research Panel recommended that to us. We've heard a lot of arguments that there's something wrong with not having a system that says to people, you will be compensated for research-related injuries. That's very broad. We've narrowed it in our discussions just to providing health care for people who are injured. The federal government has been the recipient of that advice over time, over a period of decades. And there has been no response. Now, administrations change, people in positions of authority have changed, so this is not somebody who's one administration, but it's been over a period of decades. One of the things that the Commission has agreed on is that the federal government should, for its own sake and for the sake of the American public, should give a response and say if there are reasons why they think that the system is as good as it can get now, why that is, or if not, our recommendation, and this is the tentative, is for them to actually conduct a study on what are alternate possible systems.
Inventorying existence.
What?
And inventory existing systems. In that process.
Yeah. Is that?
Amy, that seems a little bit different than how we had framed it or discussed it in the subcommittee. So we had framed it not as a single issue, but as to say, study the issue of whether or not a new compensation system is needed. And if you decide that a new compensation system is needed, then to engage in a pilot study after having studied possible mechanisms.
That's fine.
And then
But wait, okay.
And then a
Let me
second independent recommendation is, given that this is the same recommendation that both NBAC and the earlier commission provided, why is it that there has not been a response? Please give reasons for
I just reversed the order, but it's the same package.
Well, but not if they provide reasons, not that necessarily kicks in adopting a new pilot study for mechanisms. That's the only thing, the mixing was the only thing that I was.
No, I didn't, it was unintentional.
Okay.
I meant that there should be a response and the response will either be action, actually conducting something, or a set of reasons for inaction. That's the only thing I want. That is, the reason I put it first is, in my mind, it is in some sense the highest priority that there be a response after there have been so many bodies who've been asked by the government to advise, and there's nothing in writing that we or the American people can read in response. But I totally agree with the other parts, subject to, obviously we're not drafting orally, we have to sit down and do this after this meeting. Christine and then Dan, and I know we're going to take the 2 comments from the audience and we'll read them ourselves and get back to the people on this just because of time constraints. This is really, it's important. Christine and Dan.
I know we're not drafting, so this may sound like I'm worried about that, but I think that a recommendation, since recommendations often stand alone, that says the federal government should study this, in my view, is not a strong enough recommendation. I would much rather say something more strongly about the ethical responsibility and say that the current system should be evaluated and other systems be evaluated, something that makes it a stronger recommendation.
Meet the ethical
Yes.
expectations.
We're not going to draft, but we're,
Right. Yeah, I was just going to say, yeah, that the lead should be, even before that, something that, consistent with many previous commissions, at least the consensus, if not the unanimous opinion of this commission, is that there is an ethical obligation to provide compensation for medical care for persons who've been harmed.
we went, just to
Right.
clarify this.
That should be part of the recommendation, yeah.
We got past the ethical.
Yeah, but
Question.
in the recommendation, I think
We
it
weren't
needs to be,
drafting a
yeah, but it needs to be
recommendation.
stated
Okay.
so that it's
Got it.
gives the strength.
They don't focus on
Gives the
that.
strength, yeah.
Heard you. We are, before we adjourn for a break, I have one request. Because there are people here who weren't here yesterday, I'd like just the commission to go around and for you to introduce yourself so everybody knows who was speaking. Nelson, would you begin? And then we're going to take a quick break.
I'm Nelson Michael. I'm an AIDS researcher at the Walter Reed Army Institute of Research.
Stephen Hauser, Neurology, University of California, San Francisco.
Hi, I'm Lonnie Ali.
Raju Kucharapati, Genetics, Harvard Medical School.
Anita Allen, Professor of Law and Philosophy, University of Pennsylvania.
Dr. Garza, I'm the Assistant Secretary and the Chief Medical Officer at the Department of Homeland Security.
Barbara Atkinson, Executive Vice Chancellor, University of Kansas Medical Center.
John Aris, teach philosophy and bioethics at the University of Virginia.
Christine Grady, Bioethics, NIH Clinical Center.
Dan Solmacy, Medicine, Divinity, and the McLean Center for Clinical Ethics at the University of Chicago.
Nita Farahani, Law and Philosophy at Vanderbilt University.
And on behalf of the whole commission, Jim Wagner and I would like to thank Dan Wickler and Karen Moe for 2 excellent presentations and for staying with us for this whole deliberation. Thank you all.